Hi, this is Patrick Conroy again, and we're doing Chapter 8, the second part, the constitutional safeguards in criminal law. Now, criminal defendants have both state and federal constitutional safeguards. Remember, the first in the Bill of Rights, originally that only applied to the federal government and federal actions. But once we had the 14th Amendment, those protections were extended at the state level as well. So the 4th, 5th, 6th, and 8th Amendments provide federal protection, while the 14th Amendment makes them applicable to state criminal actions as well. In addition, often state constitutions have safeguards built in. The reason for this is, the state has all sorts of power. And the police can do all sorts of things. And an individual person going up against that power needs some safeguards to make sure that power isn't abused. So the 4th Amendment protection against unreasonable search and seizure. And this is a big one. This is very important when you're working either for the prosecution or the defense. Search warrants must be based on probable cause, unless the search is incident to an arrest, evidence is in plain view, or there's a high likelihood that the evidence will be destroyed. So, you're arresting someone, you pat them down, you find a gun, that's fine. You go into go to an arrest warrant, you go to someone's house, while you're arresting them, you're looking around the vicinity and you see evidence in plain view, that's fine, even though there wasn't a warrant to serve. Or if there's a high likelihood that the evidence will be destroyed. If you don't go in right away, they're going to be flushing the drugs down the toilet. Now, with businesses, business searches require a search warrant unless the business is involved in the hazardous or regulated industry. And this is why it's all so big. Evidence that is obtained unlawfully is called fruit of the poisonous tree and cannot be introduced as evidence at trial. And often that, even if in anything that relates to that evidence, that we say you find a bloody rag, and it's got the person, in someone's house, and it has a victim's blood on it. And then you go over to someone else's house and find the bloody knife. If the first search was unlawful, then not only can it not be put in, neither can anything that results from you getting that evidence be admitted. This is one of the ways that defense attorneys often try to get evidence that implicates their client thrown out. And there can be several reasons. The search warrant is faulty. It was based on less than probable cause. And there have been cases where there have been search warrants and the address was wrong, but they found evidence of crime in that other house. Should that be admitted or not? Well, was there probable cause? The frisking of people who are not under arrest is a big issue. Is there not a search? So no probable cause is needed, but there needs to be something, and it is abuse. So that's one thing you try to do. You try using the 4th Amendment to get any evidence against your client thrown out, so it won't get admitted into trial. For the prosecution, you want to make sure all of these things have been dealt with before you take the case to trial. The 5th Amendment, privilege against self-incrimination. I'm sure you've all seen TV shows and all where I plead the 5th, or a politician. The 5th Amendment prevents a criminal defendant from having to testify against themselves in a criminal trial. So you are not compelled to give evidence against yourself. Now, there was a case, Miranda versus Arizona, and it requires that a criminal suspect be informed of constitutional protections before custodial interrogation. Basically, in that case, there was somebody who was not a native English speaker being questioned and possibly, beaten up a little bit by police in Arizona. And eventually that person, confessed. But they never told him things like that he had a right not to say anything, or that he had a right to a lawyer. So after that, they came up with what are called the Miranda warnings, which is what they're supposed to read off whenever someone is arrested. You have the right to remain silent. You have the right to an attorney. You've seen that in all sorts of cop shows. There might be some variations on what is required to be said, depending on the state or even the police department. But some sort of warning of this person's rights are expected to be given. Now, the attorney-client privilege allows the defendant to tell their attorney about the case without fear that the attorney will be compelled to testify against them. The idea is you want the attorney is the voice of the defendant. So compelling them to testify would be the same as compelling the defendant to compel. There's no federal accountant-client privilege, but 20 states have adopted special statutes that prevent an accountant from justifying against a client. Now, there are some exceptions. For instance, if your client tells you that they are planning to commit a crime, that's different. Or if they're involved in an ongoing criminal enterprise, that's different. Most lawyers really, they really don't ask that question even. They're like, don't tell, I don't want to know what you did. I just want to know the sort, what went on and what possible defenses I can find. It's covering their ass. And ethical issues that we cover more in depth later. Double jeopardy. The double jeopardy protects against a person from being tried twice for the same crime in the same jurisdiction. Now, different jurisdictions can try an individual for the same act if the laws are violated in both jurisdictions. That's kind of rare. For the most part, it means, hey, you're found not guilty for dealing meth. They can't then turn around and say, hey, we have some more evidence now. We're gonna try you again for the possession of meth. No, it would have to be a different meth case. A different set of circumstances, a different time, different incident. Whether they could charge you for that. The term is prosecution gets one bite at the apple. Meaning they have to put on their best case the first time. Sixth Amendment right to a public trial. The Sixth Amendment guarantees certain rights for a criminal defendant, such as the requirement of an impartial jury and the right to cross-examine witnesses. There are federal laws like the Speedy Trial Act, which requires that a criminal defendant go to trial within 70 days of indictment. And this is a protection because sometimes, one, you don't want that person just sitting in jail because they couldn't afford bail, but they've never been tried. And also, you don't want the police just to drag this all out, hoping that they will find evidence down the road. Well, they've got 70 days. Now, it's 70 days from the indictment, not the arrest. Eighth Amendment. The Eighth Amendment protects against cruel and unusual punishment. In other words, government cannot use torture. This is why when the CIA wants to torture people, they don't bring them into the United States, they take them to like Cuba or injure. And it does not prohibit against capital punishment. Some states, their constitution protections that they would consider it cruel and unusual punishment for capital punishment. Lately, the cases I've been seeing have more to do with it's cruel and unusual in this instance, in states that allow capital punishment, having to do with the mental state or mental abilities of the defendant. You know, the person has the mental capacity of a 7-year-old. Would be cruel and unusual punishment to execute this person because of that. Okay, so that wraps up that. We have a whole course on constitutional protections. Well, this is what we have. And good luck and have a great day.